your phones and what have you to be off because interfere with the recording equipment. And both oral evidence sessions today will be unstarted. We've received an apology from the Deputy Chairman, Raymond McCartney, who's snowed in or lying in the snow or something, so he won't be making. There's no other apologies, is there? No? Okay. If we move on then to agenda item 2, which is draft minutes of the meeting held on the 10th of December. If I can ask members just to glance over those pages 6 to 12 of the meeting folder, and if you have a chance to just look through those, if you indicate if you're content for me to sign them.
Agreed.
Happy enough? Okay. Moving on to matters arising then. Responses have been received from the Department of Justice and the Human Rights Commission following the committee's request for further information about the legal action against the Department in relation to abortion law in Northern Ireland. You can find that at pages 14 to 22 of your meeting folders. The responses set out the contact that's been made both in writing and through meetings between the Commission and the Department prior to the initiation of legal action. The Commission has also outlined that it sent a pre-action letter to the Department on the 7th of November setting out the grounds for the proposed legal action. Following a letter from the Department on the 1st of December rejecting the grounds on which the proposed legal action was based, the Commission lodged papers with the Court on the 11th of December. A short hearing took place on the 6th of January to set a date for leave hearing before a High Court judge, and this will take place, as I'm sure you're aware, on the 2nd of February 2015. The Human Rights Commission has indicated that the basis for taking legal action at this point is that they believe there is an important principle to be determined, namely whether the proposals being put forward by the Department are compliant with human rights law, an obligation the Northern Ireland Executive is bound to follow, and they believe it's helpful for everyone to have legal certainty on the question of whether there is a legislative requirement to provide for termination in cases of serious malformation of the fetus, rape and incest, as it will assist the Department, they believe, in completing the consultation process. So if I can ask members just to note the current position and get agreement that we ask the Minister just to keep the committee updated of any developments. We have to do that? Yep. Okay. Moving on to agenda item 3 then. And there's a forward work programme for January and February, and you'll get that at pages 22 to 33 of your meeting folders. The meeting's been scheduled for Tuesday the 27th of January at lunchtime to accommodate the briefing by Kathleen Marshall on her report on child sexual exploitation in Northern Ireland. The date for the Minister's attendance to discuss the 2015-16 Justice Budget and the Department's response to the child sexual exploitation report findings will be confirmed as soon as possible. A brief update from the Minister on the 15-16 budget is at pages 3 to 5 of the table pack, and can I get agreement that we request a copy of the responses the Department has received to its consultation on the budget proposals to assist our further consideration on the matter? Yeah. Okay. The Minister has also provided an update on the Desert Creek Community Safety Training College and progress to deliver the Stage 2 review. The letter is at pages 15 and 16 of your tabled papers. The Minister has highlighted that, contrary to initial thinking, the Programme Board has indicated that it would not be sensible or feasible to separate the practical and academic training requirements. Therefore, the first outcome from the review will be an interim report to the steering group by the end of February detailing the assessment of all training needs. At this stage, the Board remains on track to produce their final report by April. However, the Minister has indicated that the implications of significant budget cuts and the need for the 3 service to prioritise activities to develop and implement savings delivery plans may impact on the resources available to take forward the review. He has, however, been assured that every effort will be made to minimise any delay. An informal briefing by Department officials on the development and publication of the Department's new statistics on new entrants in 1 year proven reoffending rates, as requested by the Committee, has been scheduled for 1 o'clock next week in room 21, this room, prior to the Committee meeting. We'll provide lunch for members at that as well. Agenda item 4 then is the first oral briefing receiving today. So the RQIA will attend the meeting to give evidence on the proposed amendment that had been tabled by Mr Wells to the Justice Bill. Their written submission is found at pages 35 to 41 of the meeting folder, and a summary of the written evidence received in relation to Mr Wells' proposed amendment pages 42 to 49 of the meeting folder. If we can invite Okay, can I just welcome Glenn Houston, Chief Executive, and Kathy Foley, Director of Regulation and Nursery, RQIA, to the meeting. The session is being recorded by Hansard, and the transcript will be published on the committee website in due course. So, whenever you're ready, if you just want to brief us on your thoughts, and then we'll open up to questions.
Okay, thank you very much, Mr. Chairman. I have prepared an opening statement, and I would be happy to share that with you. First of all, thank you for the opportunity of attending the Justice Committee this afternoon. On the 15th of September last year, the Regulation and Quality Improvement Authority made a written submission in response to the consultation on the Justice Bill. RQIA would wish to acknowledge that this is a complex and highly sensitive issue on which members of the public and elected representatives hold strong views. RQI's area of expertise is health and social care, and so we're not here to make alternative proposals in respect of amendments to the criminal law currently under consideration. While we acknowledge the complexities of the ethics of termination of pregnancy or abortion, we are here to identify and consider the potential impact of the legislation on our specific area of work. We believe, Chairman, that the proposed Clause 11A raises issues for regulation which we have identified and highlighted in our response to the consultation. These issues centre on the potential impact of Clause 11A for the interpretation and application of the Independent Healthcare Regulations Northern Ireland 2005 as they currently stand. RQI's written submission to this committee was informed by legal opinion as we considered it necessary to obtain legal advice on the potential implications of the proposed amendment for RQIA's role and responsibilities under our principal order, which is the Health and Personal Social Services Quality Improvement and Regulation Order 2003, and of course the Independent Healthcare Regulations in particular. We intend, Chairman, to confine our remarks to the impact of the proposed amendment and the implications that it may have for our role as a regulator. RQIA was established under the provisions of the Health and Personal Social Services Order, the 2003 Order, and Article 35 of that order states that RQIA, and I'm quoting here, Chairman, has the function of carrying out inspections of statutory bodies and service providers and persons who provide or are to provide services for which such bodies or providers have responsibility, and making reports on the inspections. There are currently almost 1,500 independent care services registered with RQIA. The largest categories currently are private dental care, nursing homes and residential care homes. Since the establishment of RQI in 2005, there's been a steady increase in the number of registered agencies and establishments every year. Each registered service is subject to annual inspection by RQIA, and the frequency of those inspections is determined by another regulation, the Regulation and Improvement Authority Fees and Frequency of Inspections Regulations, Northern Ireland 2005. So services are regulated in accordance with the relevant specific regulations and the associated minimum standards developed by the Department of Health, Social Services and Public Safety. The Independent Healthcare Regulations place a statutory duty on RQIA to register and inspect independent hospitals and clinics that meet the stated requirement for registration. Currently, there are two conditions which would require an independent clinic to be registered with RQIA. And these conditions are identified at Articles 4 and 5 of the Independent Healthcare Regulations. To summarise, Chair, these conditions for registration are firstly that an independent clinic must register if it intends to carry out a prescribed technique or make use of prescribed technology. And secondly, if a medical practitioner working in the clinic is not otherwise engaged in providing services to the HSC in Northern Ireland. In this context, the key reference in the Independent Healthcare Regulations is a medical practitioner who provides no services in pursuance of the 72 Order. Therefore, if the medical practitioner does not provide services under the 72 Order, that is, health and social care services in Northern Ireland, any surgery or consulting room where that medical practitioner is working must be registered with RQIA as it meets the definition of an independent clinic specified in the regulations. Where a medical practitioner does provide services under the 72 order, the surgery or consulting room does not require to be registered as it doesn't meet the legal definition of an independent clinic. Now, Chair, this gives rise to a legal paradox, namely that two clinics in the same town may be providing the same range of services. One will require to be registered due to the fact that a doctor working in that clinic does so on a wholly private basis. A neighbouring clinic does not fall to be registered if the doctor is also employed on either a full or part-time basis providing services within the NHS in Northern Ireland. RQI has raised this matter with the Department along with a request that it be considered as part of any planned review of the independent healthcare regulations. It is also important to consider the range of prescribed techniques and technologies as referenced in the independent healthcare regulations, which are currently listed under Article 4, and they include, for example, use of lasers, endoscopy, and in vitro fertilisation. Termination of pregnancy is not listed as a prescribed technique. Therefore, under the current legislation, there is not a requirement for an independent clinic providing such a service to register with RQIA on that basis alone. I think that's an important point, Chairman. This means that an independent clinic in Northern Ireland which provides termination of pregnancy within the law as it currently stands doesn't need to be registered with RQIA, providing that the doctors working there are also contracted to work within the NHS in Northern Ireland. The legislation does not provide for RQIA to offer voluntary registration, and RQIA will only register services that are required by law to be registered. Where an independent clinic falls to be registered under the regulatory framework, we are required to inspect that clinic on an annual basis, and that is a minimum of one inspection per annum. The requirements for registration with health and social care regulators differ across the United Kingdom. In Wales, for example, a clinic would only be excluded from the requirement to register if doctors were providing NHS services in that particular clinic. Therefore, any clinic employing doctors providing services on a wholly private capacity would be required to register with its regulator, which is the Healthcare Inspectorate Wales. In England, there are specific and detailed statutory provisions and regulatory standards against which the quality and legality of the services of the termination of pregnancy in an independent clinic can be measured and assessed by the Care Quality Commission. This provides a specific regulatory framework against which the CQC may inspect these services. To summarise this point, Chairman, under the current legislation in Northern Ireland, an independent clinic will only fall to be registered and inspected by RQIA on the basis of A, the type of services provided, and B, whether or not it employs a doctor on a wholly private basis. Currently, there is one independent clinic in Northern Ireland which, under its statement of purpose, provides a range of family planning and sexual health services and termination of pregnancy up to 9 weeks gestation. Its statement of purpose includes reference to medical abortion within the limited and strict legal criteria of Northern Ireland for clients aged 16 and above up to 9 weeks gestation. Mary Stopes International's Belfast Clinic is registered with RQIA under the provisions of the Independent Healthcare Regulations Northern Ireland 2005. It falls to be registered solely as it employs a doctor on a wholly private basis. In the event that the criminal law is amended to include Clause 11A, then an independent clinic, such as Mary Stopes, would be prohibited from providing terminations in Northern Ireland under any circumstances. In this regard, Mary Stopes would be required to amend its statement of purpose to specifically exclude medical abortion being undertaken on the premises. The clinic, however, would still fall to be registered with RQIA if it continued to provide other medical services and employed a doctor on a wholly private basis. Should Mary Stopes cease to employ a doctor on a wholly private basis, then the service would no longer need to be registered with RQIA. In this scenario, RQIA would have no mandate to enter and inspect the clinic. It is unlikely that Clause 11A of itself would prohibit the clinic from providing information to patients about termination of pregnancy or in signposting patients to registered clinics outside Northern Ireland. Clause 11A, if enacted, would make it illegal for any independent healthcare provider to carry out an abortion, as this procedure could only be performed on the premises operated by an HSC trust, with the notable exception, Chair, of the circumstances outlined in Clause 2B of that particular article. RQIA has received legal advice that has confirmed that under the current legislation, RQIA has no authority to question or challenge the decisions of a medical practitioner in respect of his or her treatment of an individual patient in any setting. Therefore, RQIA cannot question the medical practitioner's assessment of the basis on which a decision to offer a termination of pregnancy is made. In the event that RQIA became aware of circumstances which suggest that a medical practitioner had acted other than in accordance with their professional code of practice, RQIA would be obliged to refer that matter to the General Medical Council, the GMC, for further investigation. Should RQIA become aware of information that suggested that any employee of a registered service had engaged in a criminal act, RQIA would immediately refer that matter to the relevant authority, to the PSNI. RQIA is not empowered to carry out criminal investigations. However, we would and we do liaise closely with the PSNI in circumstances where we believe it is necessary and appropriate to do so. Our engagement with regulated services is based solely on providing fair and unbiased regulation to drive improvement in the quality of services for those who rely on them. RQIA would caution against any proposal which would fundamentally alter the nature and purpose of that responsibility. To conclude, therefore, Chairman, any changes to the criminal law which would have implications for the existing legislation that governs the regulation of both independent providers and health and social care trusts must be given due consideration. Any resultant amendments required to the regulations and minimum standards for health and social care would require to be taken forward either in tandem or shortly after in sequence. Chairman and members of the committee, thank you very much for the opportunity of presenting this information.
Okay, Dan, thank you very much. Members will indicate if you want to ask any questions. From the written submission and from your comments, I mean, there seems to be two areas where you're particularly concerned. One is the change in the role that RQAI would have, so you move from assessing quality to one of enforcement. If the amendment was made, are you suggesting that you would need to be working with the police on all of these issues, or any sort of role that you would have in this area?
Well, Chairman, I would begin by saying that in our current role, and as I said in my statement, we register currently 1,500 approximately different services. And there are times and occasions when we are obliged to work collaboratively with the PSNI. For example, around investigations or allegations of abuse of vulnerable adults, and we would do that routinely. Certainly, in any circumstance where any of our officers would be privy to information that ought to be shared with the PSNI, we would share that information with the PSNI because, as you rightly say, we are not an organisation which is either mandated or has the capacity or resource to conduct criminal investigations. And in our written submission, we indicated that if that were to change, we would need to employ people with particular skills in that regard, and also to work possibly in tandem with the PSNI where it were necessary to do so. And we see that as fundamentally not within the current ethos of the regulation of health and social care services in Northern Ireland.
Alban?
Thank you very much, and could I thank you very much for your very helpful submission. And could I start off by asking you, in relation to your actual role, you do not have, as it were, a clinical capacity. Would that be correct?
I'll hand over to my colleague, Mr. McGuinness, Cathy Fody, who is our Director of Regulation, and she will explain to you what we do.
If you mean clinical capacity in terms of assessment of a clinical decision making, then no is the short answer to that. It's the same as if we were inspecting an independent hospital that undertook hip surgery, we would not question the clinical decision making that led to that particular surgical procedure being undertaken. So we do not second guess the medical practitioner's actions.
Yes. Now, you did make reference to the Mary Stokes clinic. Now, my understanding from what you were saying was that it is registered with you, is that correct?
It is, yes.
Yes. And in terms of your role in relation to Mary Stokes, could you just describe that for us? I wasn't quite sure what impact that would have in terms of clinic and your role as inspection.
Well, I'll make a couple of points in response to your question, and then I'll ask Mrs. Fody to elaborate. The regulations which currently govern the activities of independent healthcare providers are the 2005 regulations. And as I said in my oral statement today, that where a clinic falls to be registered, the requirement of us under the fees and frequencies regulations is to undertake a minimum of one inspection a year of that service. If the service falls to be registered on the basis that it employs a doctor on a wholly private basis, then clearly the focus of our inspection will be around the activities of the individual clinician, and I'll ask Mrs. Fody just to say a little bit more about that.
Yes. Thank you.
The regulations, the 2005 independent healthcare regulations, dictate that Mary Stokes falls to be registered by the fact that it employs a doctor on a wholly private basis. That doctor does not work within the NHS or the health and social care in Northern Ireland in any other capacity.
Yes.
So therefore, that doctor falls to be regulated with ourselves as a private doctor, independent clinic, private doctor capacity. The independent healthcare standards, which were finalised and launched by the DHSS in 2014. There are a number of standards specifically that we would register and inspect against, and some of them, for example, would be informed decision making, what information is available to patients who come to be seen by this private doctor. Patient-client partnerships, how is that managed? How are complaints dealt with if the patient has a complaint against the private doctor? How are records maintained? Data protection, confidentiality, are they stored appropriately and are they protected? Clinical governance issues around the operation of the private doctor's practice. Staff, indemnity insurance and practising privileges of that private doctor. Is there a policy and a protocol and a contract for that private doctor to be operating within those premises? Management control of operations covers a range of things in terms of the operating hours of the clinic, the governance and management. If the doctor is administering medications, for example, it might cover safe disposal of sharps. Those are the sort of governance and management operation things. And also dealing with medical emergencies. If a medical emergency were to occur, are there sufficient facilities and wherewithal within that clinic to deal with it?
But if I could be more specific, you do not inspect any clinical decisions that are made by the doctor?
No, we don't.
You don't. So if a doctor, for example, carried out a procedure in relation to abortion, you would not be aware of that. Would that be correct?
If our focus is to ensure that the doctor is employed and is qualified and trained to undertake the procedure for which he's been employed to do, so if that doctor is employed in that capacity to provide abortion, the expectation would be that they would be trained in order to administer medications to a woman, same way if a doctor was employed to provide hip surgery, we would expect that he would be registered with the specific Royal College of Surgeons and would have the appropriate qualifications to be able to do that. I'm not sure if that answers your question.
Well, it does and it doesn't, Mr. Chairman. What I'm trying to get at is, can you go into a clinic, let's leave Mary Stubbs aside, can you go into a clinic and say, well, you know, time to time you carry out abortion procedures. Can you invite the clinic to tell you, to detail those procedures? Can you inspect the records in relation to that sort of activity?
Are you talking specifically in relation to Mary Stubbs as it operates here
Well,
in Northern Ireland?
I wanted to make it general so that,
Yes.
you know, a clinic similar to Mary Stubbs,
Okay, because
we you know, you may not want to comment directly on Mary Stubbs, so I want to try and get a situation where you can advise the committee as to what might happen in relation to your inspection in relation to abortion procedures.
Thank you. I think there are probably three broad areas, Mr. McGuinness. First of all is that we must, where a clinic is registered, it must abide by its statement of purpose.
Yes.
So if a clinic strayed beyond its statement of purpose, that would be something that we would be concerned with, and that would be something we would endeavour to address. I think secondly, the clinic must maintain, it must abide by these regulations, and as I've explained in my oral evidence, the regulations in Northern Ireland are different from regulations in other countries, including England and Wales.
Yes.
One of the challenges we have in Northern Ireland currently around these regulations is they do not specifically address or prescribe the techniques by which a termination of pregnancy may take place. However, in working within the regulatory framework, we must look therefore at what the regulatory framework requires of a clinic, and that is specified within the regulations. And you've mentioned one, the area of record keeping. Clinic must keep good records. Our ability to access records is governed by the 2003 order, and there are certain circumstances which are very clearly laid out in the order where we can access records without consent. Generally, if we're accessing records, we must do that with the consent of the patient. The exception in the 2003 order is where there is a concern identified to us that the life of a patient may be immediately at risk, and that provides an exception. But even in that exceptional circumstances, we must justify the basis on which we are taking that decision, and that would inevitably require us to seek legal opinion and be sure of our grounds.
So it would seem to me from what you're saying is that in terms of inspecting any clinic that may be involved in abortion outside the National Health Service, that your powers are limited.
They are.
Whereas perhaps in England and Wales would be different powers and a different situation, therefore.
The regulations are different and they're more extensive in relation to the procedure of termination of pregnancy or abortion.
See. Now, could I just ask you, in your written submission, you did say you had some problems. I don't know if you still have problems in relation to Clause 11A, in relation to treatment that would be carried out outside the National Health Service facilities in relation to, for example, a private clinician carrying out some treatments which are maybe borderline abortion or something of that nature. And you felt that maybe in such circumstances that what is, as it were, legitimate within the present law may not be lawful.
Yes.
I think that was the gist of what you were saying.
Yeah. Can I preface my answer by saying neither of us are trained barristers or solicitors,
Yes,
and neither of us are experts in the law.
Yes.
However, what we were attempting to do in our written submission was to identify areas that might arise as possibly unintended
Yes.
consequences
Yes.
of
No,
Clause 11A. And I think one of the questions we posed
Yes.
in relation to our written submission was, for example, how might an ectopic pregnancy be
Yes.
treated under Clause 11A if that were identified outside an NHS service? Another general point I think it's worth making is that there are many clinicians who are in private practice.
Yes.
And those clinicians in private practice, if they work also within the NHS, do not fall to be registered as an independent clinic under the regulations. And I think the issue perhaps is just how might Clause 11A extend, for example, to circumstances of that kind. Obviously, clinicians have the choice of referring people on and referring people into the NHS, and
Yes.
many would do that,
Yes.
including general practitioners. The second point that we raised, which was a question, was if an individual who had sought medical advice and on the basis of that consultation had opted to have a medical abortion within the laws it currently stands, and they were administering that medication outside NHS premises, how would Clause 11A cover that circumstance?
Yes.
And we don't have an answer to that.
Yes.
We raised it as a question.
You raised the question quite rightly, and I think, you come here independently to speak to the committee. Could I just ask you, have you looked at the Abortion Act 1967, Section 1, subsection 3? I'll just give you a copy because it may be helpful just to have a wee look at it. Chairman, just I'll read the relevant section, that subsection. It's 1 subsection 3, and it says, except as provided by subsection 4 of this section, any treatment for termination of pregnancy must be carried out in a hospital vested in the Minister of Health or Secretary of State under the National Health Service Acts, or in a place for the time being approved for the purposes of this section by the said Minister or the Secretary of State. And then it goes on to say, and I just refer to subsection 4, subsection 3 of this section, and so much of subsection 1 as relates to the opinion of 2 registered medical practitioners shall not apply to the termination of pregnancy by a registered medical practitioner in a case where he is of the opinion, formed in good faith, that the termination is immediately necessary to save the life or to prevent grave and permanent injury to the physical or mental health of the pregnant woman. Now, the point I would make to you is this, that the amendment which Mr. Wells put forward, in my opinion, reflects this subsection. I can't see much difference between that and Mr. Wells's amendment. Now, this is the substantive law under which I believe anyway, the British abortion law is in fact carried out. And the point I'm making is this, really: if Mr. Wells's amendment is reflective of that, and it doesn't cause problems of the type that you've adverted to quite properly, and I'm not in any way critical of that. If it doesn't cause problems, legal problems in England, Wales, why would it cause a problem here? Now, you may not have an answer to that question, and I respect that, but I do raise the issue because I think there's very little difference between Mr. Wells's amendment and the substance of subsection 3.
And I would bow to your knowledge on that, Mr. McGuinness. I wouldn't wish to to challenge that in any stated shape or form, but
Well, I'm not expressing a legal opinion here.
Right, okay.
No, really not.
well, whether it's a legal opinion or a personal
yeah,
opinion, I
yes,
still
personal opinion,
wouldn't wish to challenge. You did ask, quite rightly, had we looked at the Abortion Act, and I think what I can share with the committee, having referred to the situation in England in my oral statement, well, there are two things actually. There's the Care Quality Commission registration regulations, and there's also the Department of Health procedures, and they're described as interim procedures for the approval of independent sector places for the termination of pregnancy, brackets abortion. And the opening section, in fact, the opening statement in that document says the Secretary of State for Health has a responsibility under Section 1.3 of the 1967 Act, as amended by Section 37 of the Human Fertilisation and Embryology Act, to approve places other than places exempt by this section for the purpose of treatment for termination of pregnancy, abortion. All places operated by non-NHS bodies must be approved.
Yes.
So those documents may be useful to the committee.
Just my final point, Chair, is in present circumstances, outside the NHS, is there an approved place here where, in fact, an abortion procedure could take place lawfully?
The only place outside the NHS that offers that service is Mary Stopes International, and it is currently registered under the independent healthcare regulations.
But it's, as we would want to point out, England have actually written the requirements into their regulations and standards for termination of pregnancy and abortion. There is no equivalent in Northern Ireland. So there is no requirement to register a place to undertake termination of pregnancy. The place is registered by virtue of employing a doctor on a wholly private basis.
Thank you very much. It's very, very helpful.
Tom?
Thank you, Chair. Apologies for missing just the start of your presentation. I had a query just around a point from your written submission, and it's on page 4 of your submission. If it is the intention of the promoters of the clause to impose a blanket ban on private healthcare entities providing pharmaceutical, anyway, you know that paragraph?
Yes, I have it here, yeah.
Can you expand on that slightly more? Because you have given in the preceding paragraph, an example. I'm wondering, is there any wider difficulties around that, or is it limited to what you have put in the preceding paragraph?
I think the reference we made, Mr. Elliott, in the preceding paragraph was there was an example of someone in an road traffic accident inadvertently. I mean, how does the law apply in that circumstance? And that's an extension of the purposive nature of the law as opposed to the literal interpretation of the law. But I think for us, perhaps the most significant issue is what becomes of an individual who is acting under medical supervision and medical guidance, but perhaps who is administering an abortion at home as opposed to on NHS premises or in a clinic. And would Clause 11A, as it currently stands, criminalise that activity? And is that an intended or an unintended consequence of Clause 11A? And I deliberately pose it to you as a question because I'm not clear of what the intention was in that regard.
Okay. If it wasn't an intended part of the proposal, I'm assuming there is a mechanism then for getting around it, but to deal with that situation?
Well, there may well be appropriate means of, if you like, setting out exemptions, because in every piece of legislation, normally exemptions are prescribed. And indeed, in relation to the independent healthcare regulations, there are certain exemptions prescribed. For example, a service by an employer offering occupational health does not need to register as an independent clinic because it is a prescribed exemption. It may be employing doctors, it may be employing a doctor who's working on a wholly private basis for that company, providing occupational health advice, but that is a prescribed exemption.
Maybe it's not an unfair question for yourselves, but would you see it as a practice that could increase in numbers that such medication would be administered at home?
I think I would answer that, and I look to my
Yeah.
colleague Cathy to add, but I think certainly, when the 1967 Abortion Act came onto the statute book, we didn't have the internet. We now have the internet. The internet opens opportunities to individuals that were not around maybe even 5 years ago. And I suppose one of the concerns that I'm sure any healthcare provider would have would be about an unintended consequence that would drive any of this underground, where women are putting themselves at greater risk because of a fear of seeking services and help and support through a registered clinic or through the NHS.
The only thing I would add to that is, again, just following up on Glenn's point in terms of access through the internet, we have a difficulty with some web-based doctor services that you can go on to, and they don't know where you live, and the doctor at the other end of that service may or may not know that he is supplying drugs to someone who is actually resident in Northern Ireland against the law. And does that in itself make it against the law? I can't answer those questions, but those are the types of scenarios that may be subject to this.
Yeah. I'm assuming that could be happening at present as well.
It could be. We don't know.
Individuals could be sourcing medication on the internet for such purposes, and it's not known to any of us.
Yeah. Okay, thanks very much.
Okay, Edwin?
Thank you, Chair. How many abortions have been carried out in Marie Stopes Clinic?
We don't know the answer to that question, Mr. Poots.
And therefore you don't know if any of them have been carried out outside of the law?
Obviously, one follows the other.
Yeah.
We don't know the number that have taken place.
And who does know? Does the PSNI know?
I would doubt that the PSNI would know, but I can't answer for the PSNI.
Okay.
I mean, Marie Stopes should know.
And
They should be keeping a record of...
would you accept that that's not an acceptable position, that people could be operating outside of the law?
Well, I think that raises a very important question about the kind of information that an independent health clinic should be recording, and what they should be doing with that information, and what permissions there ought to be around sharing of that information with the consent of patients. And I think this is certainly a matter that I know has been a concern of this committee previously.
Yeah. Euthanasia is illegal in Northern Ireland as well, and across the UK. And if someone was offering that facility or carrying out that facility, that also be against the law.
I'm sure you're correct in that, yes.
And would therefore be unacceptable for an organisation to be doing that and holding those records without sharing them with anyone. You accept that it's inappropriate that any organisation could be acting outside of the law.
Absolutely.
And you're suggesting about sharing records with the patient's permission. I'm sorry, when it comes to the law, that becomes that particular issue. If someone is engaging in an act which is breaking a law, then you do not have the right to hold on to that information.
And again, this is perhaps something that's a very important interplay between criminal justice legislation and health and social care regulations in terms of how information should be held and captured, under what circumstances, and with whom that information should be shared. For example, should it be shared with the Department of Health, Social Services and Public Safety? Should it be shared with the Health and Social Care Board or the Public Health Agency? Should it be shared with the Regulation and Quality Improvement Authority? Those are all, I think, very valid questions and should be part of a debate.
Yeah, fair enough.
The only thing I would add to that is that our expectation is that any medical practitioner registered with the General Medical Council would maintain not only adherence to their code of conduct, but to the responsibilities of the law as it's extant. You know.
Yeah, but everybody, including the PSNI for that matter, are subject to scrutiny. And everybody has an ability to actually break the law, and therefore that's why we have scrutiny mechanisms in place. And we have a police ombudsman, for example. As an organisation, you can carry out many different inspections on people who are working in the health and social care sector. But this group, because of perhaps weaknesses in the law or things which hadn't previously been thought about, have found a gap in the law so that they can carry out work which doesn't come under scrutiny. And that's basically what the issue is. I'm not suggesting that they are breaking the law, but there is no mechanism for scrutinising that. And therefore, that is a deficiency that we need to address, and I think that's what Mr. Wells was trying to address. You expressed quite a bit of issues around the legal context of 11A. Is that coming from yourselves, or did you get legal advice to do that?
As I said in my oral statement, we felt it was appropriate to seek a legal view because we are not ourselves experts in the law, so we sought and received opinion about proposed amendments, and our written submission reflects that opinion.
Okay, thank you.
Okay. Sean?
Thank you, Chair. You state that the draft clause is ill thought out. On what key grounds do you take this view?
Well, I think perhaps there were two reasons for our queries, and one was, as I said earlier, whether there were unintended consequences of the law. And I think perhaps the second issue, and it's more an issue, I suppose, for criminal justice than for health and social care, is how do you make good law in a way that it can be policed and that it can be properly, that individuals can be properly held to account against it. And I think we wanted to point out that whereas we as a regulator have a very specific and well-defined role in regulation within the health and social care order and its associated standards, we are not a criminal justice agency, and we are not therefore well placed to police the law.
Okay, thank you.
Okay, Patsy?
Okay, thanks, Chair. We're coming really through the nub of the issue as far as yourselves are concerned. Could you talk me through there? You're in a facility, and I was listening, a facility that you regulate. What do you check within that facility?
It very much depends on the premises upon which that facility is registered
Yes.
with ourselves. So
Yes.
if it's a nursing home, we inspect against the nursing home regulations and the DHSS minimum standards for nursing homes. By the same virtue, if it's an independent clinic, we inspect against the independent healthcare standards. The standards, because they are silent on the issue of termination of pregnancy, and we're there to inspect against a private doctor service. We focus our inspection on the service, that private doctor service. How that private doctor came to be registered in that clinic, what services they provide, how they maintain their records, how they have the qualifications.
So it's, if you like, the qualification, whether that person is qualified or not, to administer or to serve within that practice or that building or that facility. Now, just let me take you to the hypothetical, and it's probably non-hypothetical because I'm sure you've been there. You'd be surprised if you haven't as an organisation. What if you discover, see, find something untoward in terms of the level of professionalism or practice that is being conducted by an individual or individuals suitably qualified? What's the trigger mechanism then?
Okay. And that does happen, you know, and it's not a hypothetical situation. It happens across a range of services, and there are a number of mechanisms that we would use. One would be, the very first thing would be to assess the impact on patients, relatives, people who are in receipt of services. And if, for example, it immediately triggered safeguarding vulnerable adults or child protection issues, we would refer those on to the relevant authorities immediately. If we felt there was an issue where we felt that the criminal law was being breached, or the law was being breached in terms of a crime being committed, we would refer that on to the PSNI, and we have protocols for joint working with the PSNI that provide us with an easy mechanism to do that.
And I think I would add another dimension, Mr. McLowan, and that is the registered provider, the registered person, as it's known in the regulations, has a duty and a responsibility, if they have a concern about the practice of anyone employed in that clinic, to address that. And that might involve also making a referral to the professional regulator. And if it's a doctor, that is to the General Medical Council. If it's a nurse, to the Nursing and Midwifery Council. And we have had conversations in the past with registered persons about that very issue.
Okay. Now, we'll presume that's the public sector. Can we move over into, say, an independent or private sector? And you alluded to that earlier. Again, if you were, is the independent healthcare regulations? Right. If you were in a premises What does your remit cover there? Is it different to within the public sector? Is the exact same remit? And again, what is the trigger mechanism or the process by which, if you find something untoward in terms of an individual professionally qualified, but nevertheless doing something which is untoward, improper or illegal, what happens then in that independent sector or private?
There would be no difference. No difference whatsoever. We still would protect the people in the first instance. We make referrals to the PSNI if that's appropriate. We refer to the professional regulator. We ourselves, as the regulator, would take enforcement action if we felt that it was a breach in regulations or, you know.
Okay. Now, I'll tease that out a wee bit further for you. How far do you go in establishing, say for example, if an illegal abortion was taking place, certainly you wouldn't hope in the public sector, but if it was taking place in a private sector or independent clinic, we'll call them, what level of evidence or information are you privy to make the call that that was illegally taking place? In other words, unless somebody discovers it and passes it on to yourselves or police or whatever, what are your powers of investigation to establish if in fact that may or may not be happening? It could be that, or it could be something else, it could be the illegal prescription of drugs, whatever.
I think, first of all, in any circumstance where there would be a concern brought to our attention, regardless of where it comes from,
Yes.
Mr. McGlone, the first thing we would have to consider is who is the appropriate authority to investigate that concern.
Yes.
And if the appropriate authority is, for example, the PSNI, then we could actually be compromising a police investigation if we step into that space and somehow or other prevent a robust investigation being led by the PSNI.
I think you're maybe picking me up slightly wrong there.
Sorry.
I'm not talking about where someone has reported it to you.
Okay.
I'm talking about your level or your capacity to discover if something untoward or illegal is happening there.
And during our inspection, we may discover something.
I'm
But
talking
that
about,
would come across something. If you're asking, do we go in deliberately to search if there has been a breach in the criminal law, the answer is no.
right. Now, I'm talking again, say people's medical files are kept in there. Do you have access to those medical files?
As I advised that we would have access to, first of all, we need to make sure that proper records are kept.
Yeah.
And that's referenced within the independent healthcare regulations. The regulations are quite specific about the records that an independent clinic should keep. They're also very specific about the range of events that an independent clinic should report to the regulator. So let me give you, for example, the death of a patient. That's the very first thing that should be reported. Any serious injury to a patient is also prescribed. Any infectious disease, any event in the establishment or agency which adversely affects the well-being or safety of any patient, and any allegation of misconduct resulting in actual or potential harm, any theft, burglary or accident in the establishment or agency. Those are the kind of things which the responsible individual is required to report to the Regulation Quality Improvement Authority. Those would be triggers to the RQIA to ask a number of questions, and depending on how those are dealt with, might also be a trigger to refer the matter on to the GMC or the police.
That's the guidance. Can I ask then, finally, just on that, have there been occasions where either public or private, among those have been listed abortions?
No, abortion's not specifically listed, Mr. McGlone.
No, I know it's not listed,
in
I
our
heard your list there,
healthcare
but
regulations.
the actual act of an abortion being listed under any of those headings?
I'm not aware of that in any stage since my time in RQIA, which goes back to 2009.
Right. That's been very helpful. Thank you. Thanks, Chair.
Okay. Thank you, Chair. Okay. Very good.
I appreciate the presentation which you made. Have you actually received any complaints about the Mary Stopes Clinic and the services which it provides?
No,
No. You have conducted an inspection there, is that correct?
we have, yes.
Were there any adverse comment made about any of the services which it provides in the inspection which you conducted?
By staff, can I ask, or do you mean
No,
by
in
complaints?
your report.
adverse comments about...
About any of the quality of record keeping or whatever?
No, we assessed the clinic and they were fully compliant with the standards and that we went out to inspect against.
I think in the
Occasionally
last, if I'm not mistaken, in the last inspection, there were no requirements or
recommendations made.
Okay, that's very helpful. Thank you.
Okay, no one else? Thank you very much. Appreciate your time.
Thank you.
Okay, members, move on to agenda item 5 then. Departmental officials will attend the meeting to brief the committee on a proposed statutory rule to enable the introduction of the new career average revalued earning pension scheme for the PSNI and PSNI Reserve. The relevant papers you'll find pages 51 to 94 of your packs. The committee has also received response from the department to issues that were raised during an informal briefing from serving police officers on the pension proposals, and a copy of that response is on page 93 in your meeting papers today. I welcome Rosemary Crawford, Deputy Director of Policing Policy and Strategy Division, Lorraine Montgomery, Policing Policy and Strategy Division, and Antonia Hoskins, Police Powers and Human Resources Policy Branch, all from the department. The session is being recorded by Hansard, and as before, the transcript will be published on the committee website in due course. So we want to brief the committee and then we'll open up to questions.
Thank you, Chairman. I welcome the opportunity to brief the committee on the proposed changes to the police pension scheme as you consider the SL1 today. Given that members will have had sight of papers setting out the detail, I will keep my introductory remarks brief to allow discussion. I would like at the outset to note that reform of the police pension scheme is part of a UK-wide government decision to reform all public service pension schemes. This was supported by the Executive in March 2012, when it was agreed that all public service pension schemes in Northern Ireland should adopt a career average model. We understand and fully appreciate that not all members of the scheme will welcome this change, but it is in line with the Public Service Pension Act 2014 endorsed by the Assembly. Reform is inevitable. People are living longer, so there is a need to ensure that pension schemes can cope with the resulting increase in demand. It is also widely acknowledged that final salary pension schemes place a huge burden on the taxpayer and can unfairly favour high earners. It may be helpful if I briefly rehearse some of the background to this issue. I and colleagues will then be happy to answer any questions the committee may have. In March 2011, Lord Hutton, having chaired an independent commission, published a report on public service pension reform. He concluded that scheme designs were not sufficiently robust to ensure the sustainability of public service pensions. He recommended changes to make these schemes simpler, more transparent and fairer to those on low and moderate earnings. 1 year later, in March 2012, the Northern Ireland Executive accepted these recommendations and agreed that the proposed career average scheme model should be adopted for all public service pension schemes, including the police. The Executive agreed to adopt this approach for each of the different public service pension schemes in line with their equivalent schemes in Great Britain, and not to adopt different approaches for Northern Ireland. The 2015 police pension scheme mirrors many of the provisions contained within the existing 2006 scheme. For example, ill health retirement benefits and other ancillary benefits will reflect the 2006 scheme. The main changes, which are consistent with changes in England and Wales, include benefits will be based on career average earnings rather than final salary. Normal retirement age for all police officers will be 60. Officers will continue to enjoy a lower normal pension age compared to that of most other public service pension schemes. Officers will retain the option to retire with actuarially reduced benefits from age 55, or indeed to work beyond 60 with actuarial enhancement. Protections will be built in for officers closest to retirement. They will be entitled to remain in their current scheme beyond April 2015 for a period determined by their individual age and length of service. Any officer within 10 years of retirement will not be affected. They will continue as a member of their current scheme. A tiered system of employee contribution rates has been built in to ensure that lower paid officers make lower contributions. The scheme addresses an anomaly so that the scheme manager may now consider withholding benefits payable to the beneficiary where they have been convicted of an offence relating to the unlawful killing of the deceased scheme member. and the regulations will introduce new scheme governance arrangements to ensure effective management and oversight. While police pensions are not subject to negotiation, the Department has engaged with the Police Negotiating Board since January 2012 as work to formulate the policy was progressed. Membership of PMB included representatives of all police staff associations, as well as employer and government representatives. It is worth noting that, as a direct result of this engagement, HM Treasury agreed to a PMB proposal put forward by the Police Federation of Northern Ireland to extend transitional protection for all police schemes from the 3.5 years initially proposed to 4 years. The Department issued a number of circulars in May and November 2013 to explain to all officers the rationale for the reforms and the impact these would have. Engagement with PMB continued right up to the formal targeted consultation exercise, which was launched in July 2014, in line with the requirements of the 1998 Police Act. The consultation period was extended twice in response to requests from stakeholders and finally concluded in November 2014. Individual officers who wished to put forward their own views were encouraged to submit these via their staff association. The Department has continued to work closely with members of PMB to amend the draft regulations in line with the detailed technical feedback received to ensure they are fit for purpose. In early December, the Committee considered an update on the results of consultation. The main thrust of the feedback received was technical in nature in respect of the draft regulations, and this has been taken forward in conjunction with stakeholders. Understandably, responses from staff associations were somewhat negative, as they expressed concern about the impact of the reforms on their members. In considering this SL1, I hope that members will be assured that the proposed reforms are consistent with the Executive's will for the reform of all public service pensions in Northern Ireland. These reforms are necessary and will ensure that police officers have access to affordable and sustainable pensions, which are amongst the very best available. The Committee will have noted the financial implications set out in the SL1. The Department is working hard to ensure the new scheme is in place by the 31st of March 2015 to avoid any potential penalty which could be imposed on the Executive by HM Treasury. I hope that's helpful, and I'll be happy to take any questions.
Just remind us of the cost to the Executive if these changes weren't to go ahead.
The estimated cost of the Treasury penalty is in the region of £6 million. Sorry, 60 million, apologies. 60 million.
60 million?
60, yeah.
And if the changes go ahead, are there anticipated savings to the budget in future years? The DOJ budget? So if we go ahead with the changes, would there be anticipated savings?
No, I think the changes are being introduced in line with the reforms of all of the public service pension schemes. There aren't anticipated savings to the DOJ budget as a result of the reforms, no.
Okay. And you'd mentioned that the decision was taken to adopt the same approach in Northern Ireland as elsewhere in the UK. Some of the representations that I've had from individual serving police officers and the Police Federation have taken this view as well, that there are unique circumstances in Northern Ireland, not just in terms of some of the policing issues that officers have to deal with, but also in terms of some of the equipment they're wearing and things like that. How would the Department propose to take those issues into account?
Well, one of the issues for ensuring that there was consistency between the two schemes, and not just in relation to police, but any of the public sector schemes and their GB equivalent, in relation to the police, the prime driver for that was to ensure the interoperability between the two schemes so that officers can move easily between one scheme and the other.
Sure.
Thanks, Chair. Reading through this, does the Department accept that some PSNI personnel feel that there should be a single scheme for them, and that this has created disappointment among some PSNI personnel?
Well, certainly the feedback that we have received from a number of satisfied officers, their focus really has primarily been on the process by which we engaged in consultation with them. The consultation process we followed was entirely in line with the 1998 Police Act and the 2014 Pensions Act. But the concerns that we were hearing from officers were about consultation as opposed to any substantive concerns about the provisions themselves.
Yeah, and even under the proposed scheme, would you accept that the exemption that firemen were granted should apply to the PSNI?
Well, obviously, the Department of Justice doesn't have any responsibility for the fire service pension scheme, but my understanding is that that exception that was introduced for the fire service was a result of an amendment being tabled during an Assembly debate, and it was an issue that the Assembly debated, voted on and agreed, and as a result of that exemption was put in place for firefighters.
And would the department accept that there should be an exemption similar for the PSNI?
Throughout the process, that wasn't a proposal that was put forward to us. It wasn't anything that we were asked to consider.
Okay, thanks, Chair.
Thank you very much, Chair, and thank you very much for your outline. The department has taken the view that the equality issues that were raised in relation to the consultation process and general issues that arise, or specific issues that arise in relation to all business and pensions for the police, the department's taken the view that they do not arise in this instance. I don't understand that for 1 minute.
Okay.
Please explain.
Certainly, the Department of Finance and Personnel has the core policy lead for all public service pension schemes. They very much are of the view that there will not be a differentiated adverse impact on any of the Section 75 groups. In spite of that, the Department of Justice undertook an equality screening exercise, and the result of that aligned with that view, that there wouldn't be an adverse impact on any of the Section 75 groups. The implications of these reforms will impact equally upon all of the officers affected.
Well, I mean, is that true? If you take the people that have been recruited to the PSNI since what, 2001, is that the operative date?
Under the pattern reforms.
So you're getting an influx of women, you're getting an influx of Catholics. You have older officers who served in the RUC who then came across into the PSNI. They benefit from the previous scheme, but in relation to this scheme, the younger officers, the different categories that I've outlined, are not going to benefit. Now, it seems to me to be a serious situation where there is this inequality of treatment, and I don't understand why the department doesn't deal with it in that way. And I have to say, just by way of comment, I think it's creating problems within the police service. And I think those problems might fester, and I think that the department still judged in not addressing these issues.
Well, in terms of reform of any pension scheme, public sector or otherwise, I think it is a fact, a consequence, that the impact will be felt greater on younger, newer members to the scheme, because more of their service will be within that new scheme. I think there is a slight additional complication for the police service and this pension scheme in that the pattern reforms were introduced at a time to address other imbalances within the police force at that time. So while it may be the case that there is a slight disproportionate impact at this stage, given the timing of the reforms, I think it would be expected that as the workforce adjusts and the composition of the workforce adjusts to more closely reflect the wider community, that impact would be balanced.
Well, I don't understand how that happens, but you know, it is disappointing the department hasn't taken that particular approach. Has there been engagement between the department and the Equality Commission in relation to this?
Yes, we've had a number of conversations with the Equality Commission about this. I believe they've had sight of our screening exercise, and if not, they certainly will have shortly. And we've engaged with them. The screening exercise will be published on the department website, so it'll be open to scrutiny. And
are you saying then in terms, I don't want to misrepresent you, but in terms you're saying that the Equality Commission is content with the approach the department's taking?
Well, I certainly can't speak on behalf of the Equality Commission, but we have.
In terms,
they are aware of what we've been doing. They're aware of the approach taken by DFP to wider public sector reforms, and they haven't raised any concerns with us.
The other question which Mr Lynch raised in relation to the fire service. If my understanding of the fire service, it was the date of retirement, correct me if I'm wrong, Chair, but it was the date of retirement that was adjusted in relation to the fire service, which means that the fire service can continue on and receive a fuller benefit from the pension.
My understanding, again,
without penalty, if they were to retire early, say around 55, I think that's the age, that there wouldn't be a reduction in the amount of pension that they would receive.
the normal retirement age for police officers under the scheme will be 60. As I understand it, while we don't have responsibility for the fire service scheme, as I understand it, the amendment that was agreed and voted on by the Assembly was that fire officers could retire between 55 and 60.
Yes, without penalty.
To the best of my knowledge, I'm not.
Well, you see, I mean, police officers under the scheme that you've proposed can retire between 55 and 60. But there's a penalty. If I retire when I'm 55 and I'm a police officer, it's somewhere in the region of, I think, 5% per annum I'm losing. So I'm losing a quarter of my pension by retiring 5 years early.
Yeah. That, as I understand, would be the case with any of the public service pension schemes. If you retire before the normal retirement age of that scheme, there are arrangements whereby you can have an actuarial reduction. Equally, you can stay beyond that date and have an actuarial enhancement. But I think it's worth pointing out that these are not proposals that the DOJ are putting forward. All we're simply doing here is giving effect to the will of the Assembly and what was agreed at the Assembly. So these aren't DOJ proposals.
Yes, I can understand that. Well, the DOJ hasn't shown any eagerness to explore an alternative.
I'm not sure that that would be a fair criticism, in that we have been engaging with the staff associations since back in January 2012 through the Police Negotiating Board, which includes representatives of the 3 staff associations. So there has been a huge amount of consultation in relation to the PMB for pensions specifically. We're discussing at least 30 meetings where that was explored. And we have genuinely considered any suggestions that were put forward to us.
Well, I think there's a division of opinion within the police service in relation to the quality of that engagement between the police. Sorry, what's the policing? Police Federation. And the department. Okay. My understanding is that there is strong discontent within the PSNI in relation to this scheme, primarily amongst younger officers. But it must be, I believe, articulated by us as MLAs. I don't know what can be done about it, but I do think it's causing problems in relation to morale within the PSNI, and the PSNI is a police service under severe stress at this moment because of the activities of paramilitaries. I don't think that that's a fair situation to allow police officers to be in. But I put that point very strongly, very bluntly to you.
Okay. I think if I can make a general point first, I think there is quite a lot of dissatisfaction amongst public service pension schemes in general and the members of those schemes, because none of us, ourselves included as civil servants, welcome the changes. It will have a direct impact on the benefits that we receive. So I think that is something that's felt right across the public sector. From what we have been hearing back from individual officers and from the associations as we talk to them, is that the concern, there has been a huge amount of consultation, as I've said, between the department and the relevant stakeholders. The sense of dissatisfaction I get is within a small number of officers as opposed to throughout the force. And I take your point. I think some of the concern has been about the way in which the Police Federation has perhaps represented the interests. But that is an internal matter for the Police Federation. It would be quite wrong for the department to try and get in amongst that relationship. under the Police Federation. It's not a government-funded body. It is appointed under regulation specifically to represent the interests of police officers. Every member of the police force is a member of the association. They're appointed automatically as they join the force. And they themselves elect their office bearers. That's very much an internal issue for the Federation, and I think it would be quite wrong for the Department to try and intervene in that relationship.
No, I understand that, and I wouldn't expect the Department to do that. That's a very fair point that you make. Just one final point, Chair, and thank you for your indulgence. The issue of the retirement age and the penalties that would apply if you retired early between 55 and 60. Has that issue been thoroughly articulated by the Police Federation in discussions with the Department of Justice?
It has. That capacity for an actuarially reduced pension to go before the normal pension age of your scheme is something that's common right across public service pension schemes. I think it's maybe worth mentioning to you that there are some specific benefits that the police will enjoy here that other public servants won't, in that the police will be able to retire with full benefits at age 60. Across the other public service pension schemes, that's now linked to state pension age. So, for example, for civil servants, they won't be able to retire under the new arrangements for civil service pension scheme. They won't be able to retire with full benefits until they reach state pension age, which for a lot of people now is 66 and is continuing to rise. So there are some protections and particular benefits built into this scheme for police officers to avail of. And other particular examples of that, I think, for them are in relation to the transitional protections that have been built in for the police. In these arrangements, they are able to access those transitional arrangements from age 34. For civil servants, they can't access that until 46 and a half. So there are benefits. And while, don't get me wrong, I fully appreciate that any member of a public service pension scheme is not going to be happy because this is a reduction in their benefits. But I think for the police, some specific protections have been built in that they are actually getting a reasonable deal compared to others.
My final question to you is this. If one were to amend these, the scheme that's been proposed, is it possible to amend it through these regulations?
Well, the SL1 that you're considering today is the Department's effort to give effect to what was agreed in the Assembly.
Yes.
So I assume that for that to change, it would need to go back to the Assembly.
So what you're saying is if we were to accept the view that's been expressed by police officers that there should be some easement in relation to the retirement age, that would require primary legislation.
The regulations that we're seeking to give effect to are a direct result from the Public Service Pension Act 2014 that was agreed in the Assembly. So we're simply doing the subordinate legislation to give effect to that.
Okay. Thank you very much, Chair.
Okay, Sammy.
A point of order, Mr. Chair. Myself, a member of my family is a member of the PSNI, so I want to declare that. But the question I want to ask, Rosemary, first of all, thanks very much for your presentation so far. And you mentioned about, I think you said, 6 million.
Yes, 60 million is the penalty.
What does that effectively mean? I mean, I can understand Albyn's points and concerns. It's a bit like with welfare reform, always had concern, but realised that every year we were going to be penalised hundreds of millions of pounds. That's £60 million. Is that a one-off fine?
I'm looking to our expert on this who tells me that it isn't. But just, I'll bring Antonio in a second. But you're right to draw the comparison with welfare reform. The legislation that's been given effect to here is UK-wide government policy in relation to public service pensions. So we're taking forward what was agreed in the Assembly to give effect to that. In that way, very similar to the issues around welfare reform. In the same sense, it will be Treasury who will impose that penalty on the Executive if we don't have this legislation in place by the 1st of April and all of
So
the
at this
arrangements
point,
around the scheme.
estimate is 60 million,
Yeah.
but could that rise?
DFP have written to all ministers to advise each individual minister that their particular scheme for which they're responsible, if there is a shortfall, they will be responsible for it, and they have intimated that that will increase over time, so it could increase, they have
Beyond the
said,
60 million.
considerably more.
So
as
the
time
cost would
goes
be met by DOJ rather than the
No,
executive holder?
it would be a penalty on the executive.
The penalty will be on the
It would be on
executive.
the executive.
We'd have to pay it for our block grant.
Yes, exactly.
And just to confirm, that's an annual
It
charge,
is
I believe?
annual, yes, and all. But DFP, the minister in DFP has written to each individual minister and has said that they will not meet the cost. The cost will come from whichever department is responsible for the shortfall. So it will come from the DFP budget. Or, sorry, DOJ budget.
Thank you. Thank you, Chair.
Tom?
Thank you, Chair, and thanks for the presentation. Police pensions, or this piece of subordinate legislation, are not subject to negotiation. I think that's what you said,
Yes, that's right.
Rosemary. Why did you enter into negotiations about them then?
We entered into discussions with the staff associations. Before we would bring forward any regulations, we would automatically consult with the 3 staff association bodies. But there is also actually a requirement in the 1998 Police Act that if changes are going to be made to a whole raft of police terms and conditions, and one of which is pensions, that the Police Negotiation Board would be involved as the policy proposals developed.
And would it have been better to carry out those negotiations or discussions whenever the main act or the main bill, piece of legislation was going through, as opposed to whenever this subordinate legislation was going through? Because you effectively couldn't do anything about it at that stage.
Well, the discussions actually started back in January 2012, so some time ago. Whenever we knew this was on the horizon, we entered into early discussion and conversations with all of the members of the Police Negotiating Board. So that's been ongoing long before the final legislation had been agreed in the Assembly.
And at that very early stage, what was the response from the organisations that you did consult with?
I'm afraid I'll have to defer to colleagues who were here at that time.
The engagement was very much informal, but it would have explored possibilities around individuals being able to retire early. It also worked with England and Wales forces to consider what challenges there might be in terms of parity across the water. So certainly there were quite a raft of more technical issues raised within the more recent meetings as work has developed in terms of drafting the regulations themselves to really do ensure that they're fit for purpose and that there are no unintended consequences in the drafting. And
But the principle, the actual principle of the pension issue, there's no huge benefit in having those detailed discussions or negotiations now, because the principle is there. And you did say it was very informal at that early stage. I'm just wondering why it wasn't more formalised then, and why there wasn't more consultation with those on the ground and those that would have been affected.
Okay. Once we say it was informal, this was conducted under the auspices of the Police Negotiating Board, which includes forces all across the UK, and would have included staff representatives, employer representatives such as the Police and Crime Commissioners and our own Policing Board representatives. So certainly there were rather formal meetings that took place on a quarterly basis, but it was more informal engagement in those meetings to get into the issues that the representative bodies had on behalf of their staff.
And did the Police Federation and others actually specifically ask for more flexibility in the pension schemes than there currently is?
If I could just clarify with Antonia, who represented us at those meetings, I believe the answer is yes, but I'll let her give the detail.
Very early on, when they were looking initially at the transitional provisions and the fact that most other schemes have 3.5 years, I don't know of any that has the 4. The Federation were quite emphatic about the fact that they wanted the 4 years, that they wanted to extend a little bit further, I think in the back of their minds was the feeling that some officers felt that they'd lost out with the severance issue, which is going back in history, and they were sure they weren't going to lose out again, you know, with this. But everybody agreed to the extension because it is obviously giving a benefit to them. It's again taking into consideration special circumstances that police have.
I think again it is maybe worth mentioning again just that, you know, these are the implications for public service pensions across the piece.
Yeah, no,
You know, so there are, you know, I genuinely don't believe that there are an awful lot of people who are being affected by these reforms who are welcoming of them and are pleased. Unions and staff associations and others have sought to engage in consultation and try to make changes. But at the end of the day, we have the legislation that was agreed by the Assembly, and this is DOJ putting it in place for the police service.
Just to clarify, I know, Rosemary, you did say earlier that there was substantive concerns. There wasn't substantive concerns about the scheme, that it was more about the consultation process. That's not what the officers have told me. They have concerns not only about the process of the consultation, but certainly about the scheme as well. Yeah. But I do understand that it is a wider civil service or a wider public service.
Well, even in terms of the officers who've engaged with us, and there have been a number, I think in terms of the letters that we've received around this, it's just over 540 individual letters. A lot of those are template letters, so saying exactly the same thing. But with that, we read each of them. And the concern, I think, just to put that in context, that represents probably about 7% of the officers who are going to be affected by this in terms of the individuals who wrote to us. But the letters that they raised, it was about equality concerns and the consistency with the departmental equality scheme process. They asked about, you know, the fact that they wanted to be consulted on an individual basis. So it was about process rather than any substantive issue around, you know, anything that would make us want to go back and look at the regulations and think that there was something wrong here. That was not what was fed through in the correspondence with us.
One final thing, Chair. Alderman McGuinness did challenge you. You know, have you looked at an alternative? Am I right in saying that there is no alternative unless you change the Act?
I don't believe it is for the DOJ to look for an alternative for this. What we are doing through the regulations is giving effect to the decision at the Assembly.
So the only opportunity to change it or make an alternative is through the Act, an amendment to the Act itself?
I believe so, but if that's wrong, I'll correct it and advise you.
Okay, thank you, Chair.
Edwin?
Thank you. In terms of police officers, obviously people who are engaged in frontline services can be very challenging physically, very challenging work, and reference was made to the fire service, and you may not want a 50-year-old person to be carrying you down 3 flights of stairs or carrying you down a ladder which is 3 floors up in the middle of the night. What can you do to offer those police officers who are not as physically fit as they were 10, 20 years previous, who are, you know, coming into that category?
I'm not sure that it would be in the department's gift to offer anything.
Well, what can the PSNI do?
Well, again, it would be the PSNI.
With the fire service, I think the fire service had very limited options in terms of desk duties or other duties. What can the PSNI do to offer, you know, alternative work other than being out in the front line to police officers?
I appreciate absolutely the point that you're making, but that would very much be an operational matter for the Chief Constable to consider in terms of who gets allocated to, you know, how he uses the resource available to him and how individual officers are allocated duties.
I wasn't asking what they do for individuals, I was asking what scope that there was to actually provide alternative sources of work, police duties, which didn't involve actually engaging in.
Again, that wouldn't be a question that I would be in a position or indeed should seek to answer. It would be an operational matter for the Chief Constable.
Okay. Okay, anyone else? Okay, thank you very much. Thank you.
Thank you.
Members, we've been asked to signal for content. I suggest we're not particularly amused or happy about doing it, but are we content to agree them, or can I take views from individuals if there's any further information they want to seek from the department?
Chair, I listened very carefully to what was said. I'm not absolutely certain that there was the earliest engagement that has been suggested. I'm not in terms of dealing with the specific issue of the retirement age itself and ameliorating the discounting that would take place if an officer were to retire early between 50 or 55 and 60. I'm not certain that that was in fact a substantive point of negotiation. I would like that clarified, because what came out from Ms. Hoskins was that there was discussion about the transition, and that the transition was raised from, I think, 3 years to 4 years, something like that. Now, that's fair enough, and that's very good, but it doesn't deal with the specific point in relation to the retirement age. So I'm not particularly satisfied that those questions have been answered in terms of the consultation, and I'm not satisfied that people say, well, the letters and the representations made were about the lack of consultation. There's no point in somebody writing to a department saying there's been a lack of consultation, and the department saying, well, you know, we've looked into it, seems to be all right, that sort of thing. The lack of consultation produced a result, and that's what I think police officers were right. So I'm not happy on that point either. And I'm not certain that the regulations are such that we cannot amend them in some way to ameliorate the situation that exists or would exist if the present proposals remain extant. And I would like that explored. Can we in some way amend the regulations that would help? And I don't think that there's a penalty involved if you do that. There's a penalty involved if you don't introduce the scheme. But the scheme can be varied in some ways. So the threat of the penalty hanging over us, I'm not certain if that is a real threat or not. I think that's thrown in to try and expedite this.
Read that again.
The final point I would make is if we can't amend these regulations, can we go to the Assembly with an amendment to the primary legislation to deal with this situation?
I'm happy to.
And I do make the point to you that we're dependent on the police to protect all of us, and to protect our society. I don't think it's right that we treat the police in this way. I think they are exceptional. I think the fire service is exceptional. I don't think it's simply good enough to say, well, public servants like everybody else, so therefore they should just have to cope with this.
Okay. Can I ask if
And
there's
we
any,
haven't heard from the police officers either.
can I ask if there's any other members of anything that they want to seek clarification on or any more information on? I mean, I'm happy to go back and we'll get that information and bring this back.
Yes.
Is there anything else that other members?
Chair, I think I would just like clarification if amending the primary legislation is the only way to change it. I know when started or SLs and SRs have come before us in the past, we haven't been able to do anything about them. All you can do is pray against them.
Yes.
So I think we just need clarification on that as well. And just be interesting to hear if there's other groups in the public sector we've heard of. NI Water obviously recently complained about the pension changes, if there are others as well. Because you could get into a fairly big minefield as well.
I think these particular ones are, you would have to only pray against that. That's right. You can't amend because of the.
We couldn't amend the rule if the department lays it. But this is the time, if you like, to engage with the department on what you're not happy with, because once they finalise what they're putting into the rule and lay it, the only option is to pray against it.
Yeah.
You can't actually amend it at that stage. But at the minute they haven't laid the rule, this is their proposal. So if there's a range of information that obviously the committee wants. It may well be worth, when we go back asking for that, to indicate to the department that we don't want them to progress until the committee has received the further information and had the opportunity to consider it. So there were, that at this stage you want to look at the proposals further, and you're not particularly content that all the issues have been explored. But if they were to go ahead and lay that rule, then the only thing you can do is pray against it. What we can do is look to see whether there's any other mechanism by which the committee could make changes, but we'd have to get advice on the primary legislation and everything.
I find it very strange the Police Federation haven't said to this committee we would like to present our views. I don't understand. They haven't communicated with me as an individual member of this committee, as other police officers have. They haven't contested the view that they misrepresented the ordinary rank and file of the police officers, that they didn't raise these issues when the negotiations were taking place. I find that extraordinary, that they haven't made some effort to communicate with this committee.
Okay. Members, is there any other information we require? No. Okay. Look, we'll go away. We'll try to get that information. We'll bring that to the system.
Well, maybe even if we had a written response from the Police Federation, we should ask them, to see here what they did, the issues that they raised at the time.
Yeah, because they seem to be blaming or laying some of the blame at the Federation's door. Officials.
Well, in fairness to the officials, they were saying that the Federation did make a case at the time, and they did put forward the points. So let's maybe just hear what they did make.
That's okay. We'll write to the Police Federation as well. Okay. If we move on then to agenda item 6, if we refer members to pages 96 to 105 of your meeting packs, the Minister and the Attorney General have both written regarding proposed amendments to the Justice Bill. The Minister is seeking views of the committee on 2 proposed amendments that relate to sexual offences against children. The First Amendment would provide for a new offence of communicating with a child for sexual purposes and would close what's considered a gap in the law relating to sexting. This new offence will be enacted in England and Wales through an amendment to the Serious Crime Act Bill, and there's already a law covering this behaviour in Scotland. The Second Amendment would make a small but significant change to the existing offence of meeting a child following sexual grooming. Currently, an adult must have communicated with a child on 2 occasions before meeting them or travelling to meet them before the offence is committed. The amendment would reduce the evidence threshold for the offence to be engaged by allowing the police to take action after only 1 contact. The Attorney General has also written providing further information which he believes emphasises the need for his proposed amendment to provide him with powers to obtain papers or information that may be relevant to the exercise of his power to direct an inquest where he considers it advisable to do so under Section 14(1) of the Coroners Act 1959. We'll be dealing with that in more detail when we have evidence from people in the Health Department about that, so we can just note the comments from the Attorney General. We'll come back to that issue, and we'll be able to do that later on. But we would seek views of members in terms of whether they're content with the amendments proposed by the Minister in relation to the sexual offences against children, or whether anyone wants any further information.
Chairman, on the proposals from the Minister, I would be more strongly in favour of the amendments that are being proposed.
Yeah.
In that we have had a history of problems in this country of people who abuse children, and therefore we need to have a very robust system to withstand that. And we have taken many steps over the last decade and beyond to provide better safety for children. So I would welcome further steps along that.
673, sure.
Are members content then with the proposal from the Minister? Yeah.
Yes.
Agenda item.
And just in relation to the Coroner's Act, we'll be hearing evidence from the health people.
Yes, and I will work on that at the end of the month, isn't it?
Yeah.
It starts next week. We're taking evidence next week and the
Yes.
following week on it.
Okay, thank you.
Okay. Agenda item 7 then, refer you to pages 107 through to 124. The Department of Justice proposing to make a statutory rule under powers conferred by Section 24 of the Public Services Pension Act 2014 to make transitional and consequential provision in relation to the police pension scheme. The committee had noted the proposal to make a statutory rule at its meeting back on the 3rd of December 2014. The Department laid the statutory rule, which is subject to the draft affirmative procedure, on the 9th of December. A second statutory rule replacing the first was laid on the 19th of December, which removed the word transitional from the title header and made further minor technical amendments to the regulations following identification by the examiner of statutory rules on a naming error. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed that he has no further issues to raise with regard to the technical aspects of the bill. So can I ask members, are they content with the statutory rule?
Agreed.
Can I ask, Chair,
Well, yeah.
does this statutory rule have any consequence on the debate and the presentation we've just received?
No, it doesn't. It's
a separate thing.
It's a separate thing, so it is. It's consequential and transitional arrangements. They allow, I think there's 3 specific areas that it will allow provisions to carry out consequential modifications for short service benefits to facilitate split pension age, transitional provisions to stop transitional members being treated as deferred members, and modifications to the tax regime in respect of ill health benefits.
Okay.
So it's not linked to the one that was just discussed.
Okay.
Yep, fine.
Then can I put the question formally to the committee that the Committee for Justice consider draft statutory rule the Police Pensions Consequential Provisions Regulations Northern Ireland 2015 and recommends that it be affirmed by the Assembly. Okay. Agenda item 8, refer members to pages 126 to 155. The Department is proposing to make a statutory rule to give effect to Directive 2011/99/EU on the European Protection Order, the policy objective of which is to provide the mutual recognition between EU member states of protection measures such as restraining orders in criminal proceedings. The committee agreed at the meeting of the 8th of October that it was content with the proposal. The Department laid the statutory rule, which is subject to the negative resolution procedure, on the 18th of December. While the delivery mechanism has changed, there has been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed that he has no issues to raise with regard to the technical aspects of the rule. So again, can I ask members, are they content with the statutory rule?
Agreed.
And then I formally put the question: the Committee for Justice considered statutory rule SR 2014/320, the Criminal Justice European Protection Order, Regulations 2014, has no objection to the rule. Yeah. Okay. Agenda item 9, refer you to pages 157 through to 198 of the meeting folder. The function of granting or refusing funding in civil cases will transfer from the Northern Ireland Legal Services Commission to the Director of Legal Aid Casework in the new Legal Services Agency once it's created. The Department of Justice proposes to make a statutory rule under powers conferred by the Legal Aid and Coroners Courts Bill, which has just received royal assent, to establish a procedure for appeals against decisions on applications for funding and provide for the establishment and composition of independent appeal panels. This statutory rule is part of a suite of secondary legislation required to implement civil legal services. The rule will be subject to the draft affirmative resolution procedure of the Assembly, and it's proposed that the rule will come into operation the 1st of April 2015. The committee considered the proposed statutory rule at its meeting on the 17th of September 2014 and agreed that it was content for a targeted consultation on the draft regulations to take place with those consultees who previously expressed views on the appeals mechanism during the initial 2013 public consultation. The Department has now provided a report on the results of the consultation, which outlines a number of minor changes is made to the draft regulations in response to issues raised regarding the appeals process and panels. Members, are we content with the proposed statutory rule?
Yep. Are we passing that today? But dealing with this today? So,
The committee's content will advise the department and then they'll go ahead and lay the statutory rule unless if the committee requires any further information, now would be the time to ask for it, or...
Yeah, okay. Fair enough.
Is that content? Just
Well, I'm sort of content. I'm not absolutely
reasonably content.
I haven't gone through the thing in minute detail yet, but anyway, it seems to me okay at the moment.
Agenda item 10 then, refer members to pages 200 through 216. The Department of Justice proposed to make a statute rule in their powers conferred by the Access to Justice Northern Ireland Order 2003. The statutory rule is part of the suite of legislation required to commence civil legal services with the transfer of powers from Legal Services Commission to an agency of the Department of Justice. It is proposed that the regulations will come into operation on the 1st of April 2015. The statutory rule will make provision for the circumstances in which cost protection will apply and when it will not apply in civil cases in which legal aid has been a feature. The cost protection regulations set out the periods in which the limit on liability under an order for costs against a person receiving funded services as part of civil legal services apply. The committee considered the proposed statutory rule at its meeting back on the 22nd of October and was content for the department to undertake a targeted consultation on the draft proposals. The consultation closed on the 4th of December. One substantive response was received from the Law Society, who recommended some drafting points, all of which the department has accepted. The Law Society also made some comments in relation to the provision for different impacts and cost protection for the revocation and discharge of a certificate and queried whether this was intentional. The department has clarified that the distinction is deliberate and no changes have therefore been made to the regulations in this regard. So again, can I ask members, are we content with the proposed statutory rule? Yeah. Okay. Agenda item 11, refer you to pages 218 through to 224. Whilst responsibility for insolvency policy lies with the Department of Enterprise, Trade and Investment, the Department of Justice is responsible for taking forward insolvency legislation through the Assembly. The Justice Department is proposing to bring forward a statutory rule to introduce a number of procedures which will make improvements in the administration of insolvencies. The rule aims to provide a better service for both debtors and creditors and will bring Northern Ireland into line with the regime in England and Wales. And it's proposed that the rule will come into operation early this year and be subject to the negative resolution procedure. The committee considered the proposed statutory rule at the meeting back on the 26th of November and agreed to seek the views of the Committee of Enterprise, Trade and Investment. The DETI Committee has now responded indicating that it is content with the policy proposals and has consulted with the Insolvency Rules Committee, which has cleared the rule. So can I ask members, are we content with the proposed statutory rule? Agreed. Okay, agenda item 12, refer you to pages 227 to 267. Back at the meeting on the 30th of April 2014, the committee agreed it was content to support the Attorney-General's proposal to include the PSNI on the list of organisations to which Section 8.1 of the Justice Northern Ireland Act 2004 guidance applies. Mr Elliott, I think it indicated he opposed the inclusion of the PSNI on the list. The Office of the Attorney-General advised that Section 8.5 of the Justice Northern Ireland Act 2004 confers the necessary power on the Attorney-General to amend the Section 8.4 list of organisations by an order. Section 21.2 makes such an order subject to the affirmative resolution procedure in the Northern Ireland Assembly. A motion to make the change will therefore require the support of the Assembly, as there is currently no mechanism by which an affirmative resolution motion from the Attorney-General can be moved. The Committee on Procedures has considered how much the statutory rule could be managed through the Assembly as part of its wider inquiry into the participation of the Attorney-General in Assembly proceedings. I just remind the committee that at the meeting on the 21st of October, the Committee on Procedures agreed a procedure to be treated as a pilot for the purposes of managing the statutory rule when it was laid by the Attorney-General. When the statutory rule is laid, it will be referred to this committee in accordance with normal procedure. In tandem, the Committee on Procedures will request the Business Office establish an ad hoc committee to facilitate the Assembly's disposal of this item of business in the plenary. So, does everyone understand that, or do we need further?
Not really, no.
Yeah.
Okay. I think what we're trying to do is, this committee back, I think it was in May, the Committee on Procedures wrote asking for the views of this committee on whether it felt it had any role in taking forward statutory rules that required a motion in the Assembly. on behalf of the Attorney-General, and the committee wrote back to the Procedures Committee indicating that it didn't feel it had a role to move the statutory rule or take the debate on behalf of the Attorney-General. It had a role, its own role, in looking at subordinate legislation. So that, I think, left the Procedures Committee with the issue of how the Attorney-General's stat rule, when he brings it forward, which he had indicated he intended to do so if the committee agreed with the proposal, would be handled on the floor of the Assembly. And what the Procedures Committee has come up with is a mechanism simply to allow the debate to take place for the affirmative resolution on the stat rule on the floor of the Assembly. This committee is carrying out its normal scrutiny of any justice-related subordinate legislation. We've got the SL1 in front of us. The Attorney-General had previously, as the committee members will know, consulted with the committee on the proposal. We had fairly extensive correspondence with the PSNI, the Policing Board, and with the Attorney-General, and the committee at the end of that agreed that it supported the proposal. The Attorney-General is now bringing forward the SL1 proposal as required to move forward the subordinate legislation. That's what you've got in front of you today. And then the Attorney-General intends to lay the stat rule in the Business Office. Again, normal procedure, and the Business Office will refer to this committee. But in tandem then, the Committee on Procedures will intend to take forward this pilot way of dealing with it, in which they'll set up an ad hoc committee, which is, my understanding, is just to provide a mechanism to get the motion on the order paper and the debate to take place. So this committee is carrying out its normal with the stat rule, and because it's a affirmative resolution, there will be a debate in the Assembly, and the chairman will reflect the views of the committee. That's the only role that we will have in it. The motion will be taken forward by the ad hoc committee. But it's basically a mechanism because currently the Attorney-General has no speaking rights, but he has, under this legislation, the right to lay down a rule that requires a debate. So we need a mechanism to move it forward, and that's the mechanism the Procedures Committee has come up with.
So can I ask, is the ad hoc committee just simply a vehicle, or will that have a scrutinising role?
No, my understanding is it's simply a vehicle. The scrutinising role rests with this committee.
At this stage?
At this stage. Even when my understanding is the ad hoc committee will be set up as a vehicle to take forward the motion. It's to get it onto the floor. Normally what would happen would be a affirmative resolution. The Minister would take forward the subordinate legislation, the motion, or if it was a committee matter, the committee chair would put down the motion. In this instance, it's an affirmative rule from the Attorney-General, but there's no speaking rights. So
yes. Well, maybe I'm going about, maybe there has been a history here and a debate, maybe before my time, dialogue on this, but why would the Minister, if in agreement with the Attorney-General, not move it himself?
I'm not sure what the position the Minister is on it. I'm not sure whether the Attorney-General has had conversations with the Minister. The primary legislation places the responsibility for making changes firmly with the Attorney-General, not the Minister. So I'm not sure whether
Maybe I could help a little bit. I don't think that the Minister, the Attorney-General can't devolve responsibility of this to the Minister.
Right, okay.
And therefore the Attorney-General has to carry it out. This is a procedural device that has been invented, for want of a better word, by the Procedures Committee in order to allow this matter to be debated.
Debate it, yeah. Okay.
And so it is, in essence, an experiment by the Procedures Committee because there's difficulty in finding a way to engage the Attorney-General with the Assembly directly, as opposed to the Attorney-General coming to a committee. Members are particularly concerned about the fact that a non-elected person would have the right of audience in the Assembly itself.
Yes.
And that was that was the unanimous view of the Procedures Committee.
Chair, just a point of information, if an ad hoc committee is then created, will the chair of that ad hoc committee promote the Attorney-General's view in the chamber? And what happens if you as chair of this committee come up with a contrary view?
I can't answer that question.
That's the experiment, is it?
I assume the Procedures Committee, in looking at this mechanism, has considered those.
Oh.
I mean, I think the Procedures Committee wrote initially to this committee to see whether it felt it had a role in doing that, and I think my understanding is this committee was fairly adamant that they did not.
No. Oh, yeah, you can understand that. There's logic there.
Now, whether they're expecting, I mean, I assume in the debate whether they simply introduce the amendment and the debate takes place, they wind, and then the Assembly votes. I think, from recollection, when this committee was looking at it, I think that was one of the issues was there wasn't any appetite, if you like, for somebody to be standing up trying to express the view of somebody else on a matter that
and the actual, sorry for butting in again, if there's a list, and that motion coming before the Assembly, or stat, if it's a stat rule, it won't be able to be amended.
The motion will be to affirm the stat rule. Because there's a motion, I assume you can put down amendments, but it's not in a negative resolution stat rule. The Attorney General, most of his guidance that we've dealt with that goes through by subordinate legislation is done by negative resolution stat rules, and there hasn't been any debate so far because the committee's been content with the guidance and nobody has prayed against the rule. The same issue would arise if if a member put down a prayer of annulment against any of those stat rules. The same problem would be there, the member would obviously move the motion, but I suppose, the issue would be the Assembly would be having a debate without, I suppose, the Attorney General's input because there's no speaking rights. I mean, the Procedures Committee, my understanding is carrying out an inquiry into this. It hasn't come to a conclusion, but the issue has arisen because of this particular stat rule and the fact that it's an affirmative one. The issue, if you like, has come to a head and they're looking at a pilot way of dealing with it.
I'm sure it'll go swimmingly.
Sure it will.
Okay. Well, can I seek the view of the committee then? Are we content with the proposed statutory rule from the Attorney General? I'm not hearing anything, but I'm seeing a few nods and a sigh.
I'll just record my opposition, not that it makes any difference, Chair.
Well, if you're content, if you don't speak now, that means where does that place you when it comes to any debate in the Assembly?
The position would be the same. I think if the committee, as a committee now, agrees that it's content with the proposal, during the debate, the chairman will stand up and reflect the views of the committee. Any member can contribute to the debate and reflect whatever view.
I obviously wasn't in the chair, but the committee has already indicated it was content.
Right. At the previous stage.
With problems.
After a long process, Chair, it went on for ages.
I'm neutral.
Is there such a thing?
Tom has noted his objection, and the committee generally content then. Rest. Okay. We shall see how it all pans out and whether this is repeated again in the future. Agenda item 13 then. Refer members to pages 269 through to 297. At the meeting back on the 10th of December, the committee considered a summary of the responses received by the Department of Justice on a proposal to introduce legislation to create an offence of police corruption for PSNI officers similar to that currently being introduced by the Home Secretary in England and Wales. The new offence is intended to supplement the existing offence of misconduct in public office, and its scope is wider than that of the existing offences that apply specifically to any improper use of an officer's powers or privileges that it's intended to give rise to benefit or detriment. The committee agreed to request further information on the financial implications of the proposal and the rationale for the decision by the Home Office that the new offence should not apply to certain categories of constables such as ports police, certain immigration officers and revenue and customs officers, and consider the issue further at today's meeting. The Department has provided the further information requested together with the views of the Attorney General on the proposal which it recently received. The Department has indicated that there is unlikely to be any significant financial implications, and the Home Office is of the view that the new offence should not apply to those officers that only have some of the powers of a constable rather than the full suite of powers and privileges, or where their powers are extremely restricted geographically, as is in the case of court police officers. The Director of Public Prosecutions, the PSNI, the Police Ombudsman and the Policing Board are broadly in support of the extension of the new offence to Northern Ireland. The Police Federation and Superintendents Association are not supportive. They say that the oversight regime for policing in Northern Ireland is very extensive, and it's not clear what the new offence will cover that's not already covered by current criminal offences. The catalyst for the new offence in England and Wales was very specific concerns in that jurisdiction, but are not, they claim, relevant to Northern Ireland. The Attorney-General doesn't support the proposed new offence, stating that the substantive criminal law in Northern Ireland is well equipped to tackle police corruption and no further legislative measures are necessary. In his view, the problem in corruption cases is giving good evidence and not any measurable gap in the law. The Minister of Justice indicated that he is minded to maintain parity on the issue and introduce a new offence of police corruption in Northern Ireland, but before coming to a final decision, he would like the views of the committee. So, can we note the stakeholder responses, and I'll ask members if they have any views on whether or not we're content to agree with the Minister that this new offence should be created. Anyone?
Difficulties.
Chair, it's an interesting one whereby there's such a divergence of opinion there. My initial look at it was, that it would have been supportive of it, obviously, with some being opposed to it, maybe it throws some doubt, but in general terms, I thought it was okay.
Yeah, Chair, similarly, we feel that it's fine.
Okay. Edwin?
I think legislation is something that you do because you need to do it. And I note that the Attorney-General is indicating that there is sufficient legislation in place to deal with the issue. I think if we're going to go down the route of doing legislation, that it should be something which adds value and not be doing things for the sake of doing them. I think we need to hear from others on this issue, including the Attorney-General, as to whether this is needed, what benefits it would bring, if any, and make a decision thereafter.
Yeah, it's not immediately clear that anyone's identified where the gaps exist, which is something that I think will be important to get more information on. And I would tend to agree that you don't create legislation for the sake of it, you do it because you need it. And if it's replicating existing legislation, I don't think it's good practice. We have a bit of time in this, do we, that we could get?
Yes, we do. I think the intention was to try and include the amendments in the Justice Bill we're looking at the minute, so we could get further information in the next few weeks if we wanted.
Will members be content can we arrange a session on that thing? I think it is important that we understand where the gaps are, if there are any, and whether or not this is required. And then if there are gaps or there are potential difficulties in the future if we don't do this, then we can make our decision then.
You want the department up on it?
I think it would be good to get the department up on it. That agreement,
The Attorney-General is due to attend in early March, early February on other aspects of the bill, so can discuss with them at that stage if you wanted, and we can get the department up before that.
Yeah, I think that would be good.
Yeah, because we have the other responses, the police ombudsman's, and that in the papers. Yeah.
Okay. Agenda item 14 then. If you refer to pages 299 to 310, and then pages 23 to 29 of the table pack for the relevant papers. The next reconstitution of the Policing Board is due to take place in May of this year, at the end of the current 4-year appointment term for independent members. The extension of the current Assembly mandate, however, has been extended by a year, so political members aren't scheduled to be appointed until May 2016. A key change, therefore, is to decouple the appointment of independent members from the appointment of political members, and the Ministers indicated that this provides an opportunity to consider the effectiveness of the appointment process for independent board members and to ensure that the board operates in the most effective and efficient manner in line with statutory requirements and best practice in respect of public appointments. Having considered a range of options in respect to the next reconstitution of the board, the Minister has decided not to automatically reappoint existing eligible independent members and instead reconstitute the board and appoint independent members by way of public appointment, and that process will be by May 2015. Members who are eligible to apply for a second term may do so. The Minister also proposes to adopt a rolling appointments model for independent members effective from 2017, whereby every year 3 independent members are appointed or reappointed. This would end the current arrangements whereby 9 independent members are appointed or reappointed every 4 years. And I think that's generally the approach that's taken on other boards that I'd be familiar with, that they roll it around rather than having all at one go. The Department has also undertaken a comparison of the remuneration levels of policing board members with other public bodies in Northern Ireland, and to assist its consideration of appropriate levels, and has indicated that the current rates are disproportionately high in comparison with other public sector board members. The Department is therefore proposing to revise the remuneration rates from the 2015 competition onwards to reflect a more appropriate level, and details are set out at page 300 of the meeting folder. The Minister intends to launch the appointment competition by the end of January 2015 so that new independent board members are in place by May, and has requested the views of the committee on his proposed new approach for appointing independent members and the revised remuneration levels. The Department has provided an updated briefing paper which was circulated electronically on the 13th of January and is in tabled pack today. The updated paper now indicates that the minimum workload of the Policing Board chairperson is 3 days per week or 156 days a year, rather than 48 days per annum as indicated in the original briefing paper. And the Vice Chairman's workload is 104 days a year rather than 48 days per annum. This changes the daily equivalent rates to £375.68 rather than £1,220.96 for the chairperson and £422.63 rather than £915.71 for the vice chairperson. The closing date for responses has also been extended until 30th of January 2015. So can I ask members, are we content with that, or are there any further questions?
No, Chair, we would have some major concerns around this, particularly, first of all, the consultation went out on the 19th when most people were switched off or others were involved in negotiations. I know that it has been extended to the 30th. And the Minister has outlined 4 options, but he has taken one of those options himself, and the rolling option. We believe that would undermine the independence of the independents. And it would give too much power to a single minister. Now, we could have any different minister within the next mandate from any single part of different parties. I think it gives them too much power over individual or independent members, and our view would be that this should be sequenced with the elected members, extended to 2016, and then have it each of the 5-year mandates after that. And our view would be that we believe that the Minister should come in front of the committee and speak on his proposals.
Okay, Chris?
Yeah, just I suppose just to echo what Sean has said, I think the justification here that the Minister using is totally defunct. You know, I don't know, if it wasn't such a serious matter, I think it'd be laughable actually in parts. You know, to suggest that a Minister can appoint, hire and fire an independent member every year. I would love to see how independent they're going to be. So if they dare step out of line with the Minister, they could be gone. To me, that's not the definition of independent. Again, if we look at point 9 in the consultation, somehow they believe that this is going to actually increase the balance of skills, knowledge and experience. This won't. You could be gone. You don't have a settling-in period. You could be gone after a year or two. Again, to me, that's actually the opposite of the case. And point 10, the model also maintains continuity and cohesion. Well, it doesn't. The longer time period you're there, you would think that the body would be more cohesion and continuity would be maintained. You know, I agree with Sean. I think the Minister has to come in front of, because he's specifically picked which one he believes we should go forward with. I think he should come to the committee and tell us why and discuss the issue at hand.
I mean, if that's a view, I'm happy enough to do it. I don't think. I mean, first of all, the appointments of independent members is done through the public appointments thing. It's not
Yeah,
just the
we know
minister who
that.
does it. In terms of the rolling aspect of it, my understanding is it's not that he picks and chooses which three would leave each year. You still serve a 4-year term, but it's on a rolling basis, which is the same with, I know I'm familiar with the Northern Ireland Tourist Board or Tourism Ireland. The board doesn't come in a whole fresh new board every 4 or 5 years. It's a bit like the House of Representatives, like in the States, where a third. That's done, and I think the basis of it is to try to keep a level of knowledge and understanding with that group. So I think it's more along those lines. I mean, we can get more information if members feel that they want the minister along, but actually my own personal view is the rolling approach actually is quite good for capacity in an organisation and a board, and it's worked. I've seen other boards work much more efficiently in this way than having a brand new board in every 4 years and having to take a while to get up to speed. So, but like if members want to get headwinds,
Most boards now would have rolling appointments. It just makes sense that you don't have a big bang approach where you could lose almost an entire board and people come in fresh and have to learn the ropes. So there's a lot of advice is able to be passed on and knowledge that exists always in a board, as opposed to having one that is completely fresh. I'd welcome the suggestions on the remuneration. I think that it does bring them more into line. I think the Health Trust chairs, which is a very difficult position, are around £40,000 a year. So it is still a fairly well paid post at £48,000 for a chair's appointment on the policing board. This one might be that publicly popular, but I do think it's grossly unfair that half the board gets paid and half the board doesn't get paid. And I know that the public representatives on the board who are carrying out the work there have a massive workload over and above their normal workload as MLAs. And most of them are actually chairing committees within the board, and I note that the payment is equivalent to the chairs of committees in the Assembly, and I don't think it would be inappropriate for the Minister to look at that. Whilst it won't be popular, and no doubt the media would attack any change on that front, nonetheless I think that people should be recognised for the work that they're carried out and rewarded for the work that they do, and the policing board is a hugely responsible position for any public representative to carry out, and brings with it a massive additional workload for any member, which takes them away from their constituency extensively.
Yeah, I mean, as somebody who's been on the policing board and the other members around the table have as well at various times, I don't think there is an appreciation just for how much work goes in just to not just the monthly board meeting, but the committees and other work that you do around that. Look, the minister's due up in front of us, not too far away anyway, so we'll maybe ask him to address this issue when he's up in front of us as well, and we'll maybe give him a chance to get feedback from elsewhere as well. And we'll have an opportunity to ask specific questions around some of the concerns that there's been. Okay, happy enough with that approach? Yep. Okay. Agenda item 15 then. Refer members to 312 to 411 of the meeting folder. At the meeting on the 1st of October 2014, the committee considered an update from the Department of Justice in the position in relation to the UK's decision to exercise its right to opt out of the 130 police and criminal justice measures that were adopted in the Council of Ministers before the Lisbon Treaty came into force, in the negotiations to rejoin 35 of the measures, including the European arrest warrant. At that time, the Department had identified that 7 of the 35 measures would require some legislative change to ensure compliance with EU regulations, and outlined that Westminster intended to introduce secondary legislation designed to allow ministers to lay regulations to implement EU decisions and directives to ensure compliance with all aspects of the measures the UK was seeking to rejoin by the 1st of December 2014. The Department has now written indicating that the EU Commission and other Member States agreed to the UK's proposals, and the necessary secondary legislation was passed in both Houses of Parliament prior to the deadline of midnight on the 1st of December 2014, enabling the UK to rejoin the 35 measures, including the European arrest warrant, from 2nd of December 2014 without any operational gap. The Department has provided a copy of the relevant order. and just ask the committee to note the position regarding rejoining 35 treaty policing and criminal justice measures, including European arrest warrant, unless anyone seeks any further information or want any further information. Happy enough to note? Okay. If we move on to agenda item 16, refer members to pages 413 through to 473. The Department has written advising the Health and Safety Executive intends to consult on consolidating legislation relating to mining operations in Northern Ireland. The draft proposes to replace a large volume of mining safety legislation with a single set of modern regulations containing shorter, more goal-setting requirements focusing on mining major hazards and do not differ in any significant way from proposals for corresponding GB regulations. Responsibility for mine safety legislation, including that relating to explosives, is shared between the Department of Enterprise, Trade and Investment and the Department of Justice. In the interest of clarity and simplification, it's preferable for explosives provisions to be included in the main consolidated regulations rather than separately in the miscellaneous mines explosive regulations Northern Ireland 1970, as is currently the case. The consultation regulations will therefore be made jointly between DETI and DOJ, with the Health and Safety Executive taking the lead on both, and the Department has provided a copy of the draft consultation document. Are we content to note the proposed consultation and consider the matter further when the results of the consultation are available? Okay. Agenda item 17, refer you to page 475 through to 561. The Department for Business Innovation and Skills issued a UK-wide consultation on the 11th of December regarding the implementation of 2 EU directives which should make pyrotechnic articles in the EU safer by making the relevant legislation easier for users to understand and apply, and also make it easier to trace pyrotechnic articles throughout the supply chain, thereby improving market surveillance and safety. This was done without seeking approval from the Department of Justice, and it's been brought to the attention of the Parliamentary Under-Secretary of State for Employment Relations and Consumer Affairs. The Department has provided a copy of the consultation document and would welcome any comments from members. Are we content, members, to note the consultation, or are there any particular comments that anyone wants to make? Have we a note? Okay. Move on then to correspondence. And there are 14 items of correspondence, pages 564 through to 670 in the meeting folder, and there's 2 items at pages 31 to 47 of your tabled papers. I will mention a few of them, and at the end of that, if anybody has any other issues they want to raise, please do so. Item 1 at page 567 is a response from the Department of Justice providing a breakdown of the 7.2 million shortfall in its saving delivery plan for 2013-14. The response advises that the full 7.2 million shortfall has arisen due to the increased cost of the Northern Ireland Prison staff exit scheme. So are we content to note that, unless anyone wants any further clarification? Have we a note? Okay. Agenda item 7, pages 645 and 646. is a letter from the Department advising that the Secretary of State intends to bring forward secondary legislation which will enable the electronic notification of public processions and related protests in Northern Ireland. At present, only personal service of an application is possible, and responses to the proposal have been positive. So can we just note the proposed change? Yep. Item 10, page 658, Strategic Investment Board, Investment Strategy for Northern Ireland Procurement Activity Report for November 2014 on the Department of Justice capital projects. The report has been provided in a new format. And are we happy enough with that new format? Yeah. Item 13, page 668, is correspondence from Mr McMaster in relation to a complaint concerning the Police Ombudsman. The committee has written to the Ombudsman to request clarification whether a formal complaint is currently being considered. Can members agree that we forward the questions raised to the Police Ombudsman and ask him to respond directly to Mr McMaster, but provide this committee with a copy of the response? Yep. Okay. Item 1, page 32 of the table pack, a copy of an additional correspondence from Mr McMaster with the Chief Constable of PSNI in relation to his complaint. Again, can I ask members if we can get agreement to forward the correspondence to the Chief Constable and ask him to respond directly to Mr McMaster, and again provide this committee with a copy of that response? Yep. Item 2, page 43, tabled pack. A copy of the further correspondence from Mr White to the Department of Justice in relation to the use of interviews under caution by the Department of Social Development. The committee has previously written to the Department of Justice and the Department of Social Development asking them to respond to Mr White in relation to his initial correspondence. I ask members if we can get agreement to forward the correspondence to the Committee for Social Development for consideration, given that the matter relates to the Department of Social Development. Yep.
Yep.
Okay. Anyone have any views on any
Sorry,
other?
and I apologise because I'm out of step here. There's something I missed that matters arising, and it is tabled today as the committee or the department's response to us as a committee regarding the budget. The draft budget 15-16. Again, can I just say, and maybe this has been covered and I missed it or I was out of the room, but we have received what is a 2-page letter, sorry, 3-page letter, responding to our response, which I think was up to 8 pages, 9 pages long, with a lot of detail on that. One of the detail within that was the railway street service. There has been no reference to that made in the response by the department, and I do believe that when you read this response, it is treating this committee with contempt. There is a lot of issues and detail that we thought needed to be in our response, and none of that has been addressed by a lot of that has not been addressed by the department. And I think we should write back as a committee asking for a more detailed response.
I think there is more information to come on this, isn't there?
Yeah, I think the department are currently working on the savings delivery plans for each of the areas, and I think mentioned them in that. We would be expecting more information on a range of issues that haven't been addressed in that particular letter. There is also other information regarding the addiction centres and whatever that we'll be looking at, so we'll follow it up.
Okay, thank you. Thank you, Chair.
Okay. Move on then to agenda item 19, Chairman's business. Item 1, can I advise the committee that the Anti-Slavery Commissioner designate, Kevin Hyland, is visiting Northern Ireland next week, and arrangements have been made to hold an informal meeting with him on Tuesday the 20th of January at 12:30 in the private dining room. The meeting will provide an opportunity for Mr Hyland to outline his role and remit, the challenges he faces and his understanding of the position in Northern Ireland, and will also provide an opportunity for members to highlight the Northern Ireland perspective and priorities. The big selling point is lunch will be provided, so if anybody would like to go along to that, can you just let the committee staff know, and we'll...
What date is that?
The 20th, Tuesday the 20th at 12:30.
Thank you very much, Chair.
Item 2. The Foyle Women's Aid invited both myself and the Deputy Chairman to a conference in Brussels on the results of the Family Justice Centres in Europe project funded by the EU to prevent and combat violence against children, young people and women, and to protect victims and groups at risk, and to celebrate their place in the new European Justice Centre Alliance Foundation. Unfortunately, neither myself nor the Deputy Chair were available to go, but we will write to Foyle Women's Aid congratulating them on their association with the new foundation and obviously wishing them well for the ongoing project. Agenda item 20 then, is any other business? Has anyone got anything else to raise? If not, the next meeting of the committee will be held on the 21st of January in this room at 2 o'clock. Thank you, members.
This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly, Committee Room 21. This is the Northern Ireland Assembly,